Well, it looks like we sort of have a decision from the judge about at least one of the motions. Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. So as of Thursday, April the 17th, it looks like we do have quite a few things being posted to the public interest website in way of the jury instructions, the trial briefs for both sides, things like that. But of course, because that is secret information that is not supposed to even be coming out until trial, hence trial brief, it's all under seal. Now, one thing that we do have is an order for the immediate family members in the courtroom, but it's not really a full order. It's sort of half and half. See, as you can see, motion to file under seal, under seal, under seal, under seal, everything under seal, until we get to this one. Now, again, this is the judge's order for the immediate family members in the courtroom. And remember, there were talks during the hearing about Bryan's family also being there. And what they're basically trying to say is that at one point they're going to be under oath on the stand. And what we heard from the defense is that Bryan's family has no intention whatsoever of testifying against him. All of the things that we've been hearing are apparently, like we thought from the beginning, all crap. The family doesn't want to even be involved in this in way of, oh, they have something to say about Bryan. That's not their intentions whatsoever. They want to be there for their son, according to what we are hearing. And Bryan desperately wants the support of his family in that courtroom. Okay, let's go ahead and read what Judge Hippler has to say. The state requests an order pursuant to Article 1, 22.4 of the Idaho Constitution and IC 19-53061B and 3, allowing immediate family members of the homicide victims to be present during the entire trial, regardless of whether they are scheduled to testify. Now, when it comes to the Goncalveses, they're really sort of the only ones we've heard anything in regards to testifying. And that's only because they are the only ones who have made a big deal about the gag order and just how far the limitations of the gag order went. There could be several other things happening with the other three families. We don't really know, do we? But I do know that it would be really interesting if we don't see Jeff Kernodle and Jasmine Kernodle also get on the stand to testify, because what did we hear? That there was something happening with Xana to where Jeff wanted to get into his vehicle around midnight and drive over there. But because he was so intoxicated, his daughter, Jasmine, Xana's sister, talked him out of going anywhere. What was the issue? What was the problem? It wasn't apparently between Xana and Ethan. So what was it that made Jeff feel that way? I'm hoping that we hear about that come trial. Attached to the state's motion as Exhibit S-1 is a list of those individuals the state considers to be immediate families under the foregoing provisions. We've gone over that list here twice. They are siblings, parents, grandparents, and step-parents of the deceased. Defendant stipulates that the individuals listed in Exhibit S-1 may remain in the courtroom during trial, but asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed as coercive to the jury. Anybody who's been paying attention knows damn well that those are about the t-shirts that the Goncalves family wore to one of the hearings, where they were basically, bring on the firing squad for this guy specifically type shirts. And there should be a courtroom decorum and etiquette followed no matter what. Big print shirts like that should not even be allowed. Even if you're just somebody who's going in to be a viewer of the public, there should be a dress code. Like, what happened to there being like traditional things that actually used to be followed? What happened to all of those things? You shouldn't be able to walk into a courtroom no matter which party or no party you might be involved or not involved with and look like you just came from the mall. That should not be allowed. The state agrees that court has the discretion to issue rules regarding courtroom decorum. At the appropriate time, the court will exercise its discretion on this regard. And there's a footnote that says, nonetheless, the parties can rest assured that those attending trial will not be permitted to display in any form or media messages, or signs of support or opposition related to the parties or issues in the case. Further, no demonstrations or outbursts of any kind will be permitted or tolerated. It goes on to say, however, in his response to the state's motion, defendant requests that his immediate family members, siblings, and parents be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on grounds that while family members of homicide victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family members. Okay, but if it's open to the public, they should be allowed to be in there regardless of what anybody thinks, because if they're going to allow the kinds of people that we saw in there the last time in there for trial, then no one can technically stop his family from going in there regardless, honestly. The state also contends that it intends to call members of defendant's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom pursuant to IRE 615. Now, just like most of us have thought since we heard about the way that the Amazon account apparently was like a family account, and that the way that they're describing it is really more like Bryan bought the gift card because it was his debit card that bought the Amazon gift card, and then that Amazon gift card was used on the Amazon account, but they're sort of wording it as to the gift card was gifted to somebody in the family and they use the same account. It's very strange the way that they're not really coming out and just claiming it, but they've made mention of, just because somebody's card and their address and their account information might have been used to purchase something doesn't necessarily mean that it's theirs. So a gift has just sort of always just like been in my mind. Like maybe Bryan did purchase something that led to the purchase of something, but somewhere along the lines, he lost ownership of something is how they're really trying to put it. So I always figured, especially since it's a family Amazon account, meaning that only his family members with access can use it, that if there was one of the other family members involved somehow in the purchase of this, so say, K-bar that they've never actually said was the K-bar that they actually think could be here, because they're not even admitting to us if it has the USMC logo on the sheath they're claiming came with this thing. They're being very vague and nondescript, and at this point, that's just more suspicious. But we sort of figured that the family member who maybe was involved in the purchase would also be called to the stand. And the defense made it very clear that his family has no intention on testifying against him, but to just come out and speak on an experience of a purchase, that's not testifying either way. It's just giving a statement of a reality, statement of a fact, of a thing that really actually happened. And honestly, even if they were to be asked other questions, why can't any of that stuff be done on day one, get it over with, and then let them do what they need to do? That's how it should be regardless. If any of the family members are going to be spoken to, they should be getting that out of the way as quick as possible so that all of the family can be where they need to be, and that's in that courtroom for both sides. The United States Supreme Court has recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant, at the very least, to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family members present at trial advances the values served by the right to a public trial, i.e., ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to a public trial is not absolute. The right to an open trial may give way in certain cases to other rights or interests. That's interesting to me that they're mentioning that, because so far we've been hearing this is going to be open and public. Something better not be changing. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of trial, is permitted if there is an overriding interest for the closure and the closure is narrowly tailored to serve that interest. Here, the purpose for the closure requested by the state is IRE 615, which provides in relevant part that at a party's request, the court may order witnesses excluded so that they cannot hear the other witness's testimony. This is a discretionary decision. Okay, so not closed, like they about to just shut it all down and make everybody freak out, because I would be freaking out. I know y'all be freaking out, okay? but just closed to the people that would be testifying. Yeah, that's what I said. That if that's the case, get it over with on day one and go back to the way things need to be. While court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that this is anticipated to be a lengthy trial and that defendant would like the support of his family. And this is footnote number 6. In addition, the court understands and emphasizes with the concerns that parents, themselves having done nothing wrong, would have and the trauma they would endure because of a child being accused of and tried for capital homicide and their desire to be present for their child. Not to testify against him and say, oh, I knew it the whole time. No, to be there for support. That's important because of everything we've heard so far. Further, the scope of his family members' testimony is likely going to be limited. In an effort to reach a resolution that upholds the rights of both parties, the court will require the state to submit for an ex parte in-camera review a list of the Kohberger family members it intends to call at trial and the purpose for calling each of them. The state must also identify why each family member cannot be called very early in its case in chief and articulate why exclusion of the family member is necessary under IRE 615, particularly given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Kohberger family witnesses, meaning pretty much everything's out there. That's coming from the judge's face. The state must submit these materials no later than April 25th of 2025. The court will provide the parties with its decision at or before the pretrial conference on May 15th of 2025. For now, the motion is granted as to the homicide victim's family and reserved as to the defendant's family. That's what I meant by it was like a half and half order. It'll be interesting if we get to see the list. Now, the judge did say during the hearing that he hasn't seen anything so far and anything that he has viewed that shows any of the family members actually coming in to testify. He said that himself. So we'll see what the state wants to do. If they were going to be called, I feel like they should have been part of the list of people that were going to be called during the time of the preliminary hearing that was supposed to happen back in 2023. And if they're not listed from way back then, I don't know what they would need to be coming to talk about now, because they would have known about the shared Amazon account way back then for the prelim. Shouldn't they have? So we'll see what they do, and maybe we'll get to see the list. I doubt it, but maybe. Now, today is Thursday, April the 17th, and normally on Thursdays, this channel goes live. I will not be going live tonight. I have a lot of things I have to do, and because my birthday is on Good Friday, tomorrow the 18th, my dad is on his way to our house, and he likes to travel on old country roads and doesn't travel with a GPS. He's got an old flip phone. Okay, so lots of times I have to get on the phone with him and we're talking about directions while I'm looking at a live map, trying to figure out where he's at because he likes to adventure. So that's what my Thursday is going to be about. And then tomorrow I'm off work. We're doing things together because it's my birthday. It's also Good Friday. So happy early Easter to all of you out there that do celebrate. I don't know if we're going to be hiding eggs. We've been doing a lot of yard work lately and doing some fence work and stuff. So I don't really know. If we're going to do that. It's cut down where I don't really think we can hide much. But for those of you that do celebrate, I hope that you have a great Easter weekend. If more information ends up populating on the case of interest site in way of new documents, after I post this video, then I will bring it to you in video form. But again, there will be no live tonight. I just got too much to do. But for now, let me know how you guys are feeling about how the judge just did this order for the family members. Let me know your thoughts down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.